Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, on Friday, while I was driving all the way across the state, all sorts of news broke. It always seems that all the news dump when it comes to Second Amendment issues always happens on a Friday, and often the Friday where I'm driving across the state. This one had to do with a ruling out of the Seventh Circuit, one that significantly affects everybody in the state of Illinois. Now, I've had an opportunity to go through this ruling. It has to deal with your assault weapon ban. And as usual, this is an absolutely horrific ruling. It seems that everything that comes out of the state of Illinois or anything related to the state of Illinois lately has been completely horrific. So today, let's get you all educated and let's talk about the awful assault weapon ruling from the Seventh Circuit. Okay, so we are talking about multiple cases today. We actually have talked about a couple of these cases before because, well, as you know, Illinois has been an absolute unadulterated dumpster fire since the beginning of this year as it relates to what used to be Second Amendment rights. Now, the lead case is a case of Beavis v. Naperville, but there's also a couple of other cases that are associated with this, which is Herrera v. Raul and Barnett v. Raul. Essentially, these are multiple challenges to the Protect Illinois Community Act, better known as Illinois' assault weapon ban, as well as their high-capacity magazine ban. There was all sorts of different rulings, depending on what court you got in. Some courts granted injunctions, some courts didn't. It was a hodgepodge of rulings, most of them upholding the laws. And so eventually the Seventh Circuit consolidated all of these cases into one case. The lead name is Beavis v. Naperville, and they have now issued a 95-page ruling on this case. Now, this is actually not a ruling on the merits. I want to make that perfectly clear. This is 95 pages, but we have not actually gotten to the actual merits of the argument. Instead, the Seventh Circuit had stayed a couple of injunctions that had been issued by trial courts, okay? So this law had been enjoined and then not enjoined, and you know the drill. It was just a complete tapestry of different types of regulations. The Seventh Circuit had stayed that injunction, leaving Illinois' assault weapon ban in place, and now has issued a ruling. And as I have stated before, when I'm about to go through a really, really terrible ruling, okay, a really terrible ruling, I do recommend you stop the video, take a few deep breaths, maybe pour yourself about 3 fingers of bourbon or get a barf bag because you are not going to like this opinion. Now, despite the fact that all of you who've been geeking out on this channel for months now knows that assault weapons, better known as semi-automatic rifles, are actually firearms which are in common use, and therefore, since they are in common use for lawful purposes, they cannot be banned. That does not come from the Bruin opinion. It comes from many years ago in a case called Heller. Now, even though we all know that, apparently the Seventh Circuit doesn't. And they have gotten very, very creative. You're going to see how they create this new rule of law because when the actual rules of law as announced by the United States Supreme Court don't get you to the result you want to get to, you got to kind of create your own laws. And this is what the court has done. Now, even though I already knew what the ruling was before I actually started tearing into the opinion, it doesn't take you very long to get into the opinion before you start realizing, this is not going to be good. The court starts off by stating, the state of Illinois, in the legislation that lies at the heart of these cases, has decided to regulate assault weapons and high-capacity magazines, a decision that is valid only if the regulated weapons lie on the military side of that line and are thus not within the class of arms protected by the Second Amendment. Huh? Exactly. I know that's what you're all saying. Now, there was no citation to that, of course. That is just this new rule of law that they're going to make up. But oh, no. The absurdity gets far more amplified as we get into the opinion. Because even though we all know what the Heller opinion stands for, and it is very, very clear, apparently the Seventh Circuit sees it a little differently. As they put it, the Heller court recognized that there was much left to be resolved. It did give some hints, however. One important tea leaf for the present purposes was its refusal to endorse the idea that the amendment protects only those weapons useful in warfare. And you can see where this is going, but trust me, the opinion gets far more perverse at that point, because I want you to pay attention to what the citation is for the next argument that the Seventh Circuit made. Under the view that prevailed until McDonald, the states were free to regulate weapons in any way compatible with their own constitutions. Now check out the site here. This is the Jeffrey S. Sutton article, 51 Imperfect Solutions, authored in 2018. And they did so in countless ways, a point of some significance when we come to consider the history and tradition of regulation in this area. And so, yeah, not only are they just citing to law review articles to help support their position, but they're also stating that, hey, all of these crazy state gun control laws should and can be used to analyze the historical basis for these regulations, which is absolutely incorrect, because we know under Bruin there is no such thing as creative or innovative gun control. Now, remember, the common use test was actually first announced in Heller and then very firmly reaffirmed in Bruin. However, the Seventh Circuit sees it this way. We think it better to ask whether a regulation bans weapons that were common at the time of the ratification, or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia, and whether law-abiding citizens retain adequate means of self-defense. This approach, we believe, is consistent with the methodology approved in Bruin. Incorrect. That is absolutely contrary to the methodology that was pronounced in Bruin. But hey, why let that get in the way of where you want to go? And so with that in mind, this is how the Seventh Circuit defined their role now under the Bruin opinion. Our task is to apply Bruin's methodology to the four laws before us. We begin by assessing whether the assault weapon bans and large capacity magazines described in those laws are arms for purposes of the Second Amendment. If not, then the Second Amendment has nothing to say about these laws. Units of government are free to permit them or not to permit them, depending on the outcome of the democratic process. To call anything out of Illinois the democratic process is a little hilarious. The court further stated, if they are properly characterized as arms, then we must proceed to Bruin's second step, at which the government bears the burden of proof and determines whether these laws pass muster. So yeah, the court is actually saying the first piece of inquiry is, does possession of semi-automatic rifles, does possession of magazines which exceed 10 rounds, is that even activity which is covered under the protected arms and the ability to keep and bear arms under the Second Amendment? Now, this should seem very, very obvious to all of us, right? However, where do you think the Seventh Circuit goes with this? Well, the first place they go is, rather than looking at American history consistent with the time that we ratified our Constitution and Second Amendment, no, they instead go back to an English Bill of Rights from 1689. So let's go back to the Bill of Rights from the country that we had to declare our independence and then fight a war to gain independence from. As the court specifically put it, this approach is consistent with historical antecedents on which the Second Amendment was based. Chief among those was the 1689 English Bill of Rights, which is a key precursor to the Bill of Rights in the U.S. state and federal constitutions. The 1689 English Bill of Rights. Now, the court points out, listen, as plaintiffs, you have to establish that the text of the Second Amendment covers this activity. That is, that what we're talking about here are, in fact, bearable arms. Now, that seems pretty obvious to all of us, right? We all can agree. Correct, right? Wrong, because this is how the Seventh Circuit put it. In order to show a likelihood of success on the merits, the plaintiffs in each of these cases before us thus have the burden of showing that the weapons addressed in the pertinent legislation are arms that ordinary people would keep at home for purposes of self-defense, not weapons that are exclusively or predominantly useful in military service, or weapons that are not possessed for lawful purposes. We find substantial support for the proposition that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. That's right. They have now created this rule that if they could be reserved for military use, they are therefore not the types of bearable arms which are protected under the Second Amendment. I'm not making it up. Take a couple deep breaths, grab the barf bag if you need to. Now, the court also then went on to further state, when we compare the AR-15 and other semi-automatic weapons covered by the Act and its counterparts, we come to the same conclusion. Indeed, we asked the plaintiffs at oral argument to explain what distinguishes AR-15s from M16s, the military counterpart that is capable of both fully automatic operation and semi-automatic operation. The question is important precisely because Heller itself stated that M16s are not among the arms covered by the Second Amendment. They are instead a military weapon. I mean, you literally can't make this up. So because we believe that the AR-15 is really kind of similar to the M16, and we believe the M16 is not covered by the Second Amendment, neither is the AR-15. You literally can't make this stuff up. And listen, I've only gotten less than halfway through the opinion, but at this point, the argument is already going down like the Titanic, and the court came to the following conclusions. Coming directly to the question whether the weapons and feeding devices covered by the challenged legislation enjoy Second Amendment protection at the first step of Bruin analysis, we conclude that the answer is no. We come to this conclusion because these assault weapons and high-capacity magazines are much more like machine guns and the military-grade weaponry than they are like the many different types of firearms that are used for individual self-defense, or so the legislature was entitled to conclude. I'm serious. No, this is actually their ruling, okay? And then the court further stated, indeed, the AR-15 is almost the same gun as the M16 machine gun. The only meaningful distinction, as we already have noted, is that the AR-15 has only semi-automatic capability, unless the user takes advantage of some simple modifications that essentially make it fully automatic, while the M16 operates both ways. Both weapons share the same core design and both rely on the same patented operating system. That's right. That is the intellectually dishonest way in which the Seventh Circuit has chosen to deal with this issue, to actually rule that semi-automatic rifles and magazines which hold more than 10 rounds are not even protected by the Second Amendment. Now, remember that this was a motion on the injunction. So the court's still given that whole, well, hey, listen, maybe injunctive relief is not appropriate here, but it doesn't mean you may not prevail on the merits. The court was quick to point out, we conclude this portion of the opinion by stressing again that this is just a preliminary look at the subject. That assessment persuades us, as it did Judges Kendall and Jenkins, that the plaintiffs have not shown a strong likelihood of success on the merits. Now, listen, there's a whole much more to the opinion, but at that point, really, they could have stopped writing because under their analysis, these are not even protected by the Second Amendment. If they're not protected by the Second Amendment, there is no constitutional implications whatsoever. Okay, once again, the case is Beavis v. Naperville. We'll link it up down below so that you can geek out on it. Now, remember, this is only the ruling as it relates to the injunction. There will still be a ruling and arguments on the merits. We all know how that's going to go, but we will keep you posted. And listen, when you take a look at all the conflicting opinions and all the gamesmanship that is being played on this particular issue, there's absolutely no doubt that the United States Supreme Court is going to have to accept review of one of these things, and let's just get this over with. Listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.